Everybody, and good afternoon. Of course, it's early morning for Prabha. And I suppose I should begin this on a very personal note, Prabha, that it's great to see you after having worked together in communication but never having met. So I think it's a really great pleasure for me to welcome you to Nalsar and to this flying research kite series that we're trying to do, where we're in a way inciting young scholars to take on areas of work and research where we feel innovative work can happen. And we're trying to kind of rope in scholars who I feel just don't do work but have like ideas on what things can be done. So it's with that spirit that we have invited you. For of course, Manisha knows you a lot better, but I said I also know her in the pages of a book kind of things. And your article on the contrast that you had set up between the wife and the whore is something that we have used quite extensively in trying to get people to understand the inside and the outside in how you understand relationships in a family. So I am Prabha is with King's College, and she's like somebody who's very closely connected with a lot of developments which happen in India. And I think she wants to keep that connection going. It's a guess. I don't know more, but I'm just guessing. Yeah. So I would most warmly welcome you to this afternoon's proceedings. And just to tell you that the way in which we do it is that we give you about an hour to make your own presentation. You can use a PowerPoint if you wish to, or whichever way you do it. And then we have about a 10 minutes break because we feel that, people should get the chance to ponder over what the speaker has spoken instead of instantly launching out on questions. And then they come back and they write in their questions. And we have Professor Vasanthi, who's been most admirably doing the moderation work. So she'll tend to cluster those questions for you so that, they're thematically addressed. And you don't have to sort of like keep watch both of the questions and to think of the answers. At the very end, time permitting, we have about something like a 15 minutes open house where if people have questions which they've not been able to type in or which have emerged from the discussion before, then they can switch on their microphones and ask you those questions. So without further ado, let's say, I welcome you, Prabha Kotiswaran, and ask you to take over the proceedings of the afternoon.
Wonderful. Thank you so much, Professor Dhanda. I hope you can hear me and can see me. Thank you very, very much for that very warm welcome. I'm really delighted, actually, to have this self-indulgent opportunity to speak about my research with all of you. And I want to also thank Professor Dhanda. That's absolutely right that you gave me an opportunity very early on, I think when I just finished my PhD, to actually contribute to this terrific book on family law in India. And I really treasured that opportunity to work with you, and thank you for that, terrific introduction to, to the Indian scholarly community, legal scholarly community. At that point, and yes, absolutely. I just wanted to say, yes, I want very much to stay engaged with what is happening in Indian law schools. So I think this is really a very valuable space within which to have conversations, in terms of how certain issues resonate all over the world and, how do we approach them based on our location, but kind of sometimes being further off offers a unique vantage point into what's happening much closer up, which you may not be able to see, and vice versa. So I think it's a very nice space to have this kind of conversation. So although I will, I have the opportunity of sharing some of my thoughts, I really do want this to be a two-way conversation. So please, I'm not sure how it works, but if you do feel like you need to interrupt me for a clarification, I'm totally happy to respond to your queries and thoughts. I'm a little less familiar with Google Meet, but I'll do my best to keep an eye on what comes up. So, I think the title of this seminar series is just absolutely terrific. Flying research kites is just such a beautiful metaphor for thinking about our research. Often, I think within the confines of institutional life, one can often forget, what a research kite is all about when you're buried under, a lot of teaching and, uh, working with students and also meeting all kinds of, performing a lot of political work that is becoming more and more urgent. So I think it's quite nice to be able to think about research guides in this fun, playful way. Um, and I do think that the field of gender and law in India today is just such an incredibly robust field with lots of exciting opportunities. So I think all of you who are considering doing a PhD, there couldn't be a better time than now, because there really are all kinds of interesting issues that require urgent and very deep work. So I think there are many opportunities, and I hope we'll have a chance to talk about them a little bit. So I guess what I wanted to just say is that, from my own experience, my PhD has been a very productive touchstone for me for my research career over the years. And I just want to share a little bit about, how the process emerges. And of course, there are people who think about the PhD in a very strategic way. And I think there are many good reasons to think about it that way. But I didn't think of my PhD in that way. It was much more organic. Maybe I should have been a little bit more strategic. I'm not sure. But anyway, I think that one of the key things is, if you do want your PhD to, if you want to use this opportunity of the PhD to ask big burning questions, I think it's very likely that you will revert back to that sort of enthusiasm throughout your research career. And that's certainly been my experience. And so, I think it's quite crucial to be quite enthused by your research project. And if not, seek out a research project that actually enthuses you before you take up the PhD. I guess I just wanted to say that, I know that you've had previous conversations with many wonderful scholars about their research trajectories. And so I just wanted to situate my own kind of interests just to frame my work. And essentially, I approach my research as a feminist legal scholar. I'm a socio-legal scholar, as one would call it. Someone who thinks about the law not simply in a doctrinal or a black letter law sense of the word as just a collection of rules that one must study and often an internal critique of, or try to understand the law as its own distinct field. Instead, I'm much more interested, like many of you at Nalsar, in looking at how law is embedded in its social context, and not just in terms of how institutions and laws appear on paper, but how they're also translated into action, but more importantly, how the law constitutes certain bodies of knowledges that could be deeply exclusionary. So I approach law in that socio-legal sense of the term, and I'm also very interested in trying to be interdisciplinary, and I think that is again both an absolutely wonderful opportunity, but also one that is fraught with risk, depending on the claims that you make about a discipline in which you're not trained. So but I have still found that I think as long as you're honest in terms of your disciplinary limitations, I think it is still quite productive and fun, not just for the legal community, but also for the discipline into which you're dabbling, for them to see some of their own blind spots in the kinds of work that they do. So these are some of my sort of commitments, being a feminist, and with that comes certain commitments to feminist praxis and being quite open to political opportunities for change, while also being a social legal scholar and also trying to be open to interdisciplinary insights from other disciplines. So I think approaching my PhD, I did my PhD at a US law school, and I think that itself was quite a different context from the context that I'd come from, which was that of the National Law School in Bangalore, where we took very seriously the idea of lawyers being social engineers. So that's always been a guiding light during my research. So I just want to say, so my dissertation research was on sex work in India, and so I had taken up this research in the late 90s, early 2000s. And at that point, still, I think it was quite interesting. It's hard to believe now, but at that point, more or less, the kinds of feminist terrain at that point was still a highly morally conservative feminist perspective on sex work, where women were viewed, mostly as victims, and also the work as being completely immoral. And then, of course, there were radical feminists who had a much more political orientation towards the conditions under which sex work is performed, and so had a very deep sense of the power hierarchies within sex work. Why is it that only women were doing it, and the kind of patriarchal capitalist context in which they were doing it, but also veering more or less to the question of thinking of sex workers as prostituted women rather than as economic actors who were performing their agency. But I think what was really also fascinating about that point in time was that, this was still at the cusp of when I think sex work researchers might have done well to have connections with the crime beat reporter to really get access to red light area. But this was already a few years after the HIV prevention activities had spawned all over the country. So there was really an incipient sex workers movement. And I think one of the first steps as part of my PhD project was at that point when these huge sex worker conferences were being held in places like Calcutta and elsewhere, was to actually go and visit. Until then, there was a sense that in these feminist debates, the opening would be to create a position where, of course, there were sex positive feminists, no doubt about it, but was to create an opening where we could actually have sex workers themselves come and speak. But that voice wasn't exactly, available. It was not really easy to go and, bring sex workers together into a conference where feminists were. But I think, kind of visiting these sex workers conferences really was an incredibly important intellectual opportunity for me, because I think that's when I had to make the leap of faith. I think as a scholar, sometimes you have to make a leap of faith, although you may not be entirely sure about how you want to think about sex workers' demands that they be treated as workers. I think taking a leap of faith actually helped, because I think both politically and intellectually. And that was, so meeting sex workers in Calcutta and trying to, seeing them evolve as sort of organic intellectuals in the Gramscian sense. They were literate, they were barely literate, but they were also trying to read, Marxist texts, trying to understand the relationship, which they knew. They had a lived experience of the relationship between marriage and sex work, but their articulation of it in political terms, in feminist terms, was a very important point for me through which I could guide my own research. I could self-direct my research towards trying to understand what a materialist feminist theory of sex work might actually look like. And also, I think it was a provocation for thinking about labor law in a creative way, because they were saying, well, we are workers and we demand workers' rights. So what does that really mean? What are the spaces within the body of labor law to think about labor law, a labor law that would actually, respond to the demands of sex workers? And I think also having some sort of, I think the materialist feminist push also was an incentive to look at the material conditions of sex workers' lives. And I think that was really crucial from a legal perspective for me, because trying to do empirical work in Sonagachi, in the brothels of Sonagachi, I realized that although many of the conversations around sex work were very much around the ITPA, the Immoral Traffic Prevention Act, is it enforced or not? Should we decriminalize or legalize? Those are the kind of limited sets of legal questions that were being asked at that point. But I think actually being on the field and trying to ask some more probing questions about the economic conditions of sex workers really alerted me to what was far more fundamental in determining their bargaining potential in Sonagachi. And that was really the question of property rights. So, you can, and I think this, again, threw light on the long-standing legal realist insight, which is that, you may have a certain set of rules that seem to be the most self-evident in engaging with a certain social problem, but the reality is that there is another set of background legal rules that always determine, people's bargaining power. So I think looking at, the application of rent control laws in Sonagachi was quite illuminating in terms of seeing, how the modes of organization of work and the trajectory of sex workers' lives within Sonagachi was very much tied into their investment in the local property economy. So I think here is again, this. So I think, before I knew it, actually, what I was trying to do was some kind of ethnographic work, or at least approaching the situation there through an ethnographic sensibility. And I think, although I would never claim that I'm an ethnographer, I think what was interesting was that there's a robust literature on sex work all over the world. I mean, there are just fantastic studies by feminists everywhere, and I think this is really, really quite critical. And many of those scholars are really ethnographers or sociologists, but one often found that actually their understanding of the law was quite limited. So, they wouldn't really, there was less attention even in their ethnographies to social norms and the resilience of social norms and the interaction between social norms and legal rules and the state, so they didn't really have an account for how the law works. So I think there is always some benefit to bridging some of these interdisciplinary conversations. And then that's where you locate gaps. You locate gaps in terms of, are feminist legal scholars doing enough empirical work? Are the ethnographers asking enough sufficiently strong questions about the role of the law or social norms on the ground? So I think this is quite useful. And so I think this dissertation project has been the launching pad for thinking more critically about both interdisciplinary questions. So one of the offshoots of the research was to really work with a group of other socio-legal scholars who are also very interested in the relationship between the economy, society, and law. So with a few collaborators, Amanda Pericasaris and Diamond Ashakbor, who are colleagues at SOAS, we produced, we had reading groups around the economic sociology of law, which was also very kind of interesting. But it was also something that fed very much into my teaching, because I think for lawyers, this is often a question of, you have to teach law at the end of the day, whereas, your feminist ethnographer friends go off and there's much more of a close alliance between what they teach and the research. I think for lawyers, it's slightly different because you're dealing with the entire body of the law. So in my case, it was criminal law. So there was an opportunity to think about the criminal law and to teach criminal law in a rather more critical way. So I think, and that, of course, led to, and I'm happy to talk about teaching, and to hear your thoughts as well on how, you manage your teaching commitments with your research. And of course, there's a whole other separate conversation to be had on publications. What are the publication strategies? Because I think it is useful to be a little bit strategic about your PhD, depending on where you see yourself, professionally, and, what is it that your professional context demands of you in terms of your PhD research. Certainly in the UK where I am, a book is essential. So, then you really reorient your PhD research towards producing a book. So, of course, we can talk about this. There are many different ways of approaching this question of publications. So, I guess just continuing with the intellectual journey, I think again, being very closely involved as an academic activist with the social movement, in this case, the sex workers movement, also showed that, the conversation internationally was moving very quickly from, anti-sex work laws to thinking about trafficking. So this is, 2000, the Palermo Protocol, supplementing the Transnational Convention on the Convention on Transnational Organized Crime was being debated and came into force. So this was there was a way in which the questions around sex work were being recast and reframed internationally, domestically, locally, everywhere. I mean, you could feel the pressures of the state wherever you were. If you were in a red light area, you were seeing a lot more police raids. You were seeing a lot more anti-trafficking organizations really shutting down red light areas. So there was a sense in which one had to traverse, legally speaking, the entire kind of range of operation of the law. So there was another whole set of publications and books that I sort of wrote around the question of trafficking. What happens at the transnational level? What happens at the domestic level as transnational law is translated into domestic law, and then how is it then operationalized locally? So this is again a very fascinating kind of way for lawyers to think about their own work. And I think by now, as you can tell, the momentum around thinking about criminal law, was really building up. So I think I was approaching criminal law both in my teaching and my research from a deeply kind kind of critical way, almost suspicious manner, because you really see how sharp the tools of criminal law are, and how the disproportionately perverse effects that they can have on the ground. And I think, speaking to, we realized that a group of us who had been thinking about feminist engagements with criminal law found that this was not only in the area of anti-trafficking that we were seeing this immense, attachment to the criminal law. We were seeing that actually feminists were very invested in the criminal law as well. And this was very, very surprising because, obviously both in the Indian context and I think second wave feminist movements around the world have had a very deeply suspect relationship with the state as well as with the criminal law. So, but we were beginning to see that certain schools of feminist thinking were finding traction in being attached to the state and to the criminal law. So I think, so a group of us scholars were really thinking about it from the perspective of what Janet Halley calls governance feminism. And it wasn't completely even. It wasn't that we were finding feminists becoming influential only in the area of criminal law. We were finding feminists who are also influential in other areas of the law, including, say, in family law, where the way that they were thinking about the law and policy was catapulting them into fairly influential positions from where they could initiate large law reform programs. So we thought very carefully about how to capture this. And I know that there is a lot of misunderstanding around the question of governance feminism, but we don't really think of governance feminism as a necessarily negative trait. I think all of us in some way or the other can become governance feminists when there is a need to speak to the state in terms of law reform. So we flit in and out of these positions. But the question is, do we have some kind of self-awareness about, our responsibilities and how we, engage with the state? So I think, this then led to, and of course, I think all of us, it's fair to say, there are occasions, I think, in everyone's lives where there are, some very crucial political moments that actually shift people's entire kind of research agendas. And certainly, I think, Jyoti Pandey's rape and murder in 2013, certainly in 2012, certainly did that for me to a certain extent, because I hadn't really been thinking, although I was teaching criminal law, hadn't really looked very deeply into, rape law reform in India. Certainly in the UK, I'd studied the Sexual Offences Act of 2003. And, when you teach it, you kind of have a very nice narrative of what actually happened here, what the law reform processes were that led to the passage of the 2003 Act. And there were just decades of consultations that the Home Office had commissioned on, what was happening with rape law and why was there a justice gap? Why weren't there enough convictions for rape? There were lots of kind of sociological studies of the attrition rate and what was happening within various institutions as rape prosecutions passed through them. So coming with that kind of knowledge, what happened in 2012 was, of course, deeply kind of pushed what feminists had been working on for decades, which is sexual violence really to the fore. And I think initially thinking about governance feminism and looking at what was happening around the world, and particularly in the US, where there's a different set of political developments and socioeconomic developments which led to the formulation of carceral feminism. It was very tempting at that point to think about Indian feminist critiques of the criminal law as far more sophisticated and far more advanced compared to how US feminists, especially radical feminists, were thinking of the criminal law. But I think here again, so it's true that, given the vast amounts of informality in our legal system, that Indian feminists have always been very attuned to legal realist insights on the law, that we know that there is a huge gap between the law and the books and law and action. We also have a very sophisticated understanding of how only certain experiences find their way into the law. I mean, we really had this very deep understanding, of formal law and how the state manipulates the law in its own interests. But I think so. Initially, what appeared to be the kind of critique of criminal law that was coming from Indian feminists was quite fascinating to watch. But I think as one went further behind, once one started looking from 1983, when the last amendment to the IPC had happened, to seeing what was the narrative of the Indian feminists thinking around sexual violence, I found that maybe one had to take pause and think about whether we've been as critical of the state as we might have thought in a prior moment of our debates in the late 70s and the early 80s. Anyway, I won't kind of rehash some of these arguments around governance feminism and the 2013 reforms, but I think so I think sometimes looking back at this kind of trajectory over a 30-year period can give us a more critical take on what feminists themselves have been doing in the area of criminal law. So, of course, these are always, these are not easy positions to take. They're somewhat risky, but I think it's generally, even if one is, whether one is right or wrong, I think it's always an occasion to, take stock of where we are. And I think we've done that quite brilliantly within the Indian women's movement. But at times it felt that during those debates that the spaces for critique were quite fraught. I wouldn't say they were, I would say they were limited, but they were also deeply fraught. So I think there's also an issue of, when do you take risks in your intellectual journeys to ask, difficult questions. So I think now I just want to shift gears a little bit, because I think there is something about, traversing legal fields. And, for a very long time, I've been quite gotten comfortable within thinking about, criminal law and feminist critiques of criminal law. But I think one of the key things that took me back to my PhD research was to really rethink, as Professor Dhanda said, about the relationship between marriage and sex work. And I think more broadly about the relationship between marriage and several other satellite economies of women's labor. So going back to the question of women's labor, I started thinking about, what are the various forms of women's labor and how does the law actually deal with these forms of labor? And so that's the sort of current research that I'm engaged in, which is to think about various forms of women's labor, including sex work, but also erotic dancing, including bar dancing, also looking at commercial surrogacy, as well as paid domestic work and unpaid domestic work. It's quite interesting that if you look at the struggles in relation to each of these areas of women's work, there are clearly identifiable political actors, there are feminist actors, and there's also default legal understanding of these sectors of women's work, and that often becomes the terrain on which all the debates then happen. So within commercial surrogacy, question is, should we allow it? Should we not allow it? Should we prohibit it? Should we not prohibit it? And what are the legal tools? And most often one defaults to thinking about contract law as a means through which to negotiate the protection of surrogates' rights, but also trying to shift that conversation more towards labor law and to see whether surrogates might be better off if we shifted the legal terrain. Similarly, with erotic dancing, often the default legal terrain is of licensing law. And the question is that adequate for meeting the needs of sex workers? So it's in a way trying to keep reinvestigating what might be a better legal frame through which to recast some of the feminist political debates, but some of the legal debates, and some of the activist debates around these questions. So I think this then has led me to think about different forms of women's work. And one of the areas that I've been looking at since 2012 has been that of the unpaid work of homemakers. And of course, many of us, many of the lawyers I know would know very much about.
Prabha, a small request. Could you speak a little louder?
Yeah, sure. Sorry, I have a
Yeah.
cold, which is why.
Oh, okay. I mean, it's.
Yeah, yeah.
I'm growing old, so I think I need little more resistance.
Okay.
Thank you.
Sure. So so I think many of us have watched, repeated pronouncements from various high courts around, women's unpaid work under the Motor Vehicles Act, talking about how actually women's unpaid work should be recognized, under the law. So this is something that I've been looking at for several years. And what has been interesting is that this is an area of private law, which, I hadn't been familiar with. So the area of tort law. And to see, what are the kinds of reasoning techniques that courts were using really to recognize women's unpaid work. And it's quite fascinating. Again, here, if you go back, 25, 30 years, you actually see there are some very interesting lessons on how, certainly how tort law was taught to me at the National Law School was as, a private law area, which is governed, more or less we draw on English common law. But I think as I saw some of these cases develop within the body of Motor Vehicles Act jurisprudence, it was very clear that very early on, certainly in the 1970s, Justice Krishna Iyer was already talking about tort law as a major form of redistribution, that it should be tort law is not merely private law. It's not simply about, a case filed by the defendants of the deceased person against the insurance company, but actually there are deeply redistributive consequences that we need to take into consideration. So I think it's so tracing the developments in the Motor Vehicles Act and how it has become a means of redistribution over time has been very interesting. And I think there are some very important decolonial moves that the courts have made over time, which I think, of course, everyone talks about this case law in terms of how they've recognized women's work. But I think what is also quite fascinating, and I think is something that needs to be shared very broadly, is how Indian appellate courts actually took the question of, they could have just confined themselves to reimbursing the dependents of these women who are deceased by simply saying, well, we are awarding damages for loss of consortium, or some pecuniary damages. But what they did actually was to look very carefully at women's unpaid work as an occupation and then treated it on par with, an occupation that a man would have undertaken, for which he would be compensated had he died. So I think there are some very interesting breaks that the judges themselves have introduced into this zone of, tort law jurisprudence that we need to think about very carefully. So I think, and of course, there is, again, looking at tort law, I think in the Indian context, maybe, the kinds of scholarship around tort law, one would expect, certainly in the US context, you would expect economic analysis of tort law. And that would be a sphere through which you would, because sometimes your critical project is shaped by who you are in conversation with or in opposition with. And certainly I think in the US context, the ascendance of law and economics analysis of private law areas is quite crucial. So you find a lot of progressive tort scholars really critiquing, law and economics scholarship on tort law. I think it's a little less so in the UK context and possibly much less so in the Indian context. But I think that was also kind of interesting to look at how feminist tort law scholars, again, of which there are many very fantastic works across the world, was trying to bring feminist critiques of tort law in conversation with more left-leaning law and economics critiques of tort law. In conversation then with more decolonial approaches to tort law that was emerging from, Indian judges. So, so I think, I've probably sort of spoken too much, but, this is, so I guess I just want to underline how, although there is the field of gender and law in India today is very robust and there are lots of interesting projects happening, I think one should never think that, the opportunities for interesting work are reduced or exhausted by any means. I think there's just so much work that still needs to be done, in all these sort of areas of the law, in almost every area of the law, in the Indian context from a feminist perspective. So I think I will just sort of stop there, and I look forward to any questions that you might have.
So I sort of just will do 2 takeaways from this, and then have our break and come back and have our extended conversation with Prabha. I think one of the things which came out big way for me, Prabha, was that, as law people, we are constantly also encouraged very much to stay within whichever specialization we pick up for ourselves. I think your entire narrative, what it brought out was that, it's not like you talk in terms of labor law and family law and criminal law, and, the interconnections between them can itself help you etch out a sort of a space and an analytical connection which may not otherwise arise. I thought, that at least came through very loudly for me, that, that how you kind of literally sort of looking at, say, motor accident law or tort law, and then to be seeing what is the position of the woman within the family, how exactly do you look at the whole phenomena of unpaid work. And, it's like these linking ups which are all happening within the realm of law, but they're not staying in any standard boundary or specialization. We've been sort of talking quite a lot on the potential of intradisciplinarity. Interdisciplinarity we talk about quite a bit, where you go into another discipline. But this is like what sort of potential arises when you look at connections within the discipline. So I thought that was one thing which rang up for me. And because we've been saying it in different ways in the other talks we've had with the participants, I thought I'll highlight it. And maybe at some point when we talk further, you may want to, sort of amplify what you're saying here. And the other thing also, of course, was this subtle kind of line wherein these boundaries get created because of certain unwritten norms of morality, where you sort of believe that, this is not an issue, that these two can't be talked about together. That kind of, and it's only something which is prejudice dictated, which is dictated because those categories got created at a certain point of time. And hence, like the point with which I started, basically because I suppose, you can't talk about the wife and the whore together, sort of things, that sort of business. The sex worker who's actually paid for her work, and the woman who's unpaid for the sex that she provides for, exactly what's the relationship between them, to believe that you can't talk about these two together. I was just as I was processing what you were saying, it's like how much traditionally ordained categorizations, classifications influence us in the first instance, till we look at our own politics, look at our own prejudices and say, why am I doing this, kind of things. Why do I believe that these two can't be spoken of together? Or why shouldn't I don't join the dots because I really think they belong to two very different territories. So at least these were my two big takeaways, because again, when you talk about innovation or to talk about original work, how much of it has got to do with the lens that you're using, and what are the things that you don't see at all because of the fact that you're, whether it's prejudice or whether it is the way in which you've been taught something, like you're saying, or we were taught law in this kind of a manner. Hence, the other ramifications, the public policy ramifications of tort law, one doesn't appreciate at once. We talk about, in feminist theory, we talk about the personal political, and we say, okay, how what is seen as personal and what is seen as not is itself a political decision. And yet we ourselves kind of get entrapped into that entire, at least I think for all of us at some point or the other, what feminism taught us was to learn to reconstruct, to learn to reconstitute and say, okay, this has been handed out to me, but is this how it should be seen. So if you have some immediate response, you can. If you feel that you want that 10 minutes break, if you're also battling with a cold, then I think maybe you want that cup of tea, and we can come back and then just throw it open, and Vasanthi will take over from that.
Okay. Yeah, no, I think I completely agree with you. I think that's a very nice way of framing it, the interdisciplinarity. And I think that's where it's a very tricky thing. And I think one always kind of, it's a challenge, I think, within a law school environment to actually make those connections happen. On the one hand, it's the only place where it can happen, right? It's only through your law school research seminars that you're constantly dipping into other areas of the law to see what is happening. And you're finding that they are struggling with very much the same questions that you're probably dealing with, questions of agency, questions of coercion, questions of consent. Somebody in medical law is dealing with, someone in criminal law is dealing with, it's an issue in contract law. So it's very, but those conversations don't always, happen. And I think especially if you're a social legal scholar, I think depending on how doctrinal your colleagues are, you're constantly bridging that divide as well. So I think interdisciplinarity is a very powerful way of thinking about, and I think it's really quite critical right now, I think, in the Indian context, because to a certain extent, so many of us are by default social legal scholars because of the way in which we think about the law as being deeply political all the time. There's a loss in terms of being doctrinal enough in some ways, but also being able to step out of the doctrinal boundaries when necessary. So kind of, I think for legal scholars, it's a particular challenge to be able to amass the riches of everything that's happening within social movements and outside law schools, but also bringing it back in to train students so that they can ask all the sharp analytical legal questions to push it forward. And oftentimes, I think the state, obviously, we are still deconstructing and working through all the categories, but the state, actually has this oversight over all areas of law, and they're able to make interconnections so well, that it's remarkable. Actually, I would almost say that it's not a luxury, the interdisciplinarity. I think it's an urgent political necessity as of now to really be able to see, because I think the entire legal fields are being shifted, labor law, criminal law. I think none of you are strangers to that. None of us, nobody needs to be told this. They're shifting so rapidly and realigning in such critical ways that I think these conversations are more urgent than ever. And I think the thing around the boundaries and prejudice, I think that's exactly right. I think it is prejudice that doesn't allow us to look beyond these boundaries and to unpack them. And what's very fascinating is that people who can deconstruct certain sets of boundaries are not able to deconstruct other sets. So you will find, and this is not just, a problem with those in power. It's a problem also with feminists or even social activists within a certain area where, a domestic workers trade union may not really want to sit across the room from, sex workers union. So these are very deeply entrenched silos that, despite being a feminist, we may not be able to really politically break down. So yeah, I completely agree with you.
I mean, we also see. Remember when we look at all the debates around the CEDAW and that whole umbrella approach. I mean, where they wanted to flatten the differences between women, and in the process alienated a large number. Is, I think, one of those dramatic examples of, all right, how this so-called category of woman itself became an alienating concept. It became a way of saying who is the woman we care for and who has to wait her turn, so to say. Whether it was women with disabilities or whether it was women, with, who was speaking in terms of sexuality in a different kind of mode. It was a whole range of people whom you were ousting out in the process. And this was happening so-called within the women's movement. You were trying for a women's convention, but what you did in the process is that you alienated a large number of women. And you work it out and you look at, say, what happened with the disability convention, you have a different kind of phenomena happening there. But at least they tried. They tried this whole business of leapfrogging, and they understood the issue of intersectionality a lot better than was understood when we did CEDAW, So, I mean, it's like the point that you were making about that, to find it within feminist literature, or within feminist thought, the prejudice is not like something which only is found in, governance structures or with state agencies and stuff. So, yeah, I do think that this could be further thinking on. So I suppose we take our 10 minutes break. Prabha goes and gets herself a cup of tea, which she needs. And I suppose all of you do too. And you type in your questions into the chat box. And Professor,
we have a range of questions here from, how does one look at traditional concepts in labor law, to questions of how do we do gender justice, and some very practical questions about how do we formulate research questions when we go about an area. But I thought what I would want you to start off with is that you, in your presentation, highlighted this whole business of blurring of boundaries. So we're no longer looking at, categories of labor law, criminal law, or international law, human rights law. So in this fluidity and in this blurring of boundaries, how difficult is it for scholars to begin their research? And, for example, there's a question which says, okay, I'm new to gender studies, right? So you haven't actually talked about gender studies. You were saying criminal law and family law and various things. And is gender studies like an entirely different area from law? Or how would you want to understand this whole business of gender studies? And the problem I'm seeing, especially from the students' point of view, is how does one then learn to navigate those terrains? Because they're unfamiliar to you, you don't know where to start, and what are the works you must look at. How do you know who was the most authoritative person in a particular area? This is something that we constantly see candidates struggling with. So if you want to talk about that.
Yeah, I think that's, those are really tough questions, actually. And, it could be that I don't think there's any right or wrong way of doing it. There's no authoritative way of doing it. I think often, sometimes you could spend years looking at a certain area and think actually you've exhausted looking at all the research in it, and then actually discover, for no fault of yours, that in fact somebody out there, a lost soul like you, is also looking at the same research questions, has actually probably published a book on it, which you don't know about. And I think it has to do with the nature of publications and this kind of the context in which we are working. Certainly if you're interested in, if you're feminist, if you're feminist, you're very interested in what's happening politically and social movements. You're trying to grasp all of that's happening dynamically. You're also trying to grasp what's happening within legal scholarship. You're also trying to look at, if you're an interdisciplinary person, you're looking at what's happening in other disciplines. So I think it makes sense to to have that ambition, but start out really in a very discreet fashion. Do it in the way that your supervisor would ask you to do. Really identify. First of all, I think you need to understand, figure out what is it that's, agitating you. What is it really that, what's the hunger within you? What's the research question you're really struggling with? And then articulate that, break it up in terms of what it might look at, what it might look like if you were to produce research questions out of it. And I think, and then is to really read quite extensively, in some of the leading journals. I think once you've reached a saturation point of people who are referring to certain canonical works in that area and reading those canonical works, I think that by that time, I think you would have a good sense of what is the lay of the land and what is it that you're most interested in when discussing that. So I think it's very, very difficult trying to be an activist, be an academic, look at different areas of law and be interdisciplinary. So I think it's good to have a very discrete legal project to begin with, or even within gender studies, if that's what you're interested in, have a home discipline where you get a good sense of how people in that field, in your discipline, are actually discussing the issue before you then go outwards to, you can always rework your research questions in light of something new that you've read, but it makes sense to have a solid grounding, because at the end of the day, even if you write something for your own discipline on a certain issue, chances are you're really making a valuable contribution to that discipline. And I think, you can then, there's always opportunities for having, maybe you can work with somebody else, you can collaborate with somebody else, who's from another discipline, and then they bring to bear. I mean, you don't have to do everything yourself. You can often, collaborate with other people who are looking at it from another discipline, and then you work collaboratively together to identify what are the strengths and drawbacks approaching a certain question from both disciplines. I don't know, is that useful?
Yes, yes. I think what I really liked about what you're saying is also that, you don't necessarily have to confine yourself to any particular source from which you want to draw. Or that, you don't have to really look at authoritative ones, because I think that's one of the first things that we teach when we want to say you think critically and think like a feminist is possibly all the authorities are not going to go your way. You would probably need to think against the grain, argue against the grain in a whole range of areas. And so you should find something to read, not necessarily in law. And that's something that, Professor Parasharan also was talking about yesterday, that don't stay within the legal discipline and expect to find really exciting research. There's a lot of research that's happening outside the legal framework.
Absolutely. And I think in the Indian context, it's really nice because I think law schools are not restricted to, I mean, there's a certain sensibility that there isn't, law isn't a kind of imperialist discipline that's trying to, constantly make claims about, how we've got it right first, or we know better. I think in the Indian context, law is just, one discipline, and there are lots of, in a certain sense, it's sometimes problematic because some of the, so for example, if you look at labor laws or if you look at the farm laws, you'll often find that a lot of non-lawyers are actually writing about these areas. And I think that's valuable in a certain way because they're identifying the core political questions on that issue. I think you can take that and then unpack the legal part of it, because that is what is missing, and there aren't enough lawyers to often do this. So, I'm also notes editor for the Indian Law Review, and this is a constant struggle that I have in commissioning pieces, because often you have to approach non-lawyers and pair them up with a lawyer to actually write about these very critical issues, burning issues. So I think, so I think that's the other way. You can read outside and then, bring your legal expertise to bear on those questions. That would be a huge contribution. Certainly, as someone who's scanning the legal field all the time for publications, I can say very confidently that it would be a contribution to the legal scholarship.
So this idea of trying to look at what are traditional concepts, whether within labor law or criminal law, so then how does one, engage with these so-called traditional concepts, and then how does one, does one engage in this whole idea of dismantling them or pushing the envelope? How do you see research happening there?
Yeah, I think the provocations can come from different places. I think it can come from lived experience, as just seeing, and I think that's part of the feminist consciousness raising, right? I mean, is to trust what you see politically and feel politically. So it can come certainly from lived experience. I mean, if it's a question of domestic work, for example, it's something that is an everyday experience. I think just looking around you, you can learn a lot from why the labor law actually doesn't speak to the realities of the people that you see around you. So I think it's just a question of trusting your intuition. That's at a very basic level. I think another way of trying to provoke thinking around it, to actually contextualize what you're reading, right? Because everything that is written is not, it's not handed down from some authority who is the final word on it, right? They are also approaching it as a scholar with a limited set of tools and, from their disciplinary background. I think just contextualizing it and saying, actually, they are looking at so-and-so things from this period to this period, and they're not actually saying a lot of other things, is to then fill in all those gaps. So I think contextualizing what other people are saying, bringing to bear on it, insights from reading very widely, from reading, people in other disciplines, or even just, the newspapers. I mean, this is actually pretty much how a lot of the PILs have happened, right? Some of the most path-breaking PILs were literally judges, like in the bonded labor cases, judges simply telling amicus curiae to go out and ask a few questions, and that's what then feeds into the legal vocabulary to see how lacking it is. So I think, contextualizing, these bodies of scholarship are very important. And certainly in the context of labor law, for example, just knowing that, formal labor laws apply only to 8% of the working population, and that 92% are outside, and that actually, a state-based law, so this is again, I think, if you're looking at it from the state, so shifting the scales of analysis, going from national law to say labor law at the state level, because that's where many of the innovations have come from, because local movements have been able to reframe certain categories of labor law. And I think just trying to see what is shifting the scale, I think, can also help you see, that can identify the parochial nature of certain legal interventions, to then, to rethinking, and also to constantly, I think, not be too attached, not have certain commitments, not have very strong commitments to any particular outcome, to always bracket it. So in this context, so this question that Devika has asked about unpaid work, absolutely right. You think when you're thinking about work, it's labor law that you think about. That's exactly the right intuition. And I think for a lot of paid work, you would say, well, labor law is there. We're labor law warriors. Absolutely, yes. But I think in this context, it would be to just bracket it and to understand what has happened with domestic workers' struggles. Why is it that we don't have a sector-specific law, right, for domestic workers themselves? And then to say, well, maybe the answer is not in the law either, right? Because not all political answers come from the law. And, so for example, certainly some of the recent work I've done on wages for housework, what is really happening is the conversation is coming from feminist economists, and the proposals are coming from political parties, and they're talking about cash transfer, they're talking about welfare schemes. So this very delicate dance between the law and schemes is something that we need to kind of understand. And I think initially, you may not really immediately know how they all fit together, and it's a larger puzzle that we all have to figure out. Is there anything left in the law? Can we rely on any rights in the law? It's a huge question, I think, for labor lawyers. Or has it all been devolved in the form of government schemes, right? So I think this is always a question that's there, but I think initially you can certainly ask, is law the answer to it? It may turn out that actually law is not the answer, and but sometimes it's also to also be creative about what law you want. What do you think would be the legal solution? I think it's, so for example, many of us have been working on, anti-trafficking law. The problem is always that there is a set repertoire that the state uses and presents it to you, then you critique. But sometimes the position of critique produces its own blind spots that doesn't allow you to be creative. So sometimes I think you have to say, yes, the political work of responding with a critique to this draconian law, I will do this now, but let me turn my gaze and say, what would I like instead? And you'll be surprised by how much you think you can actually come up with. And that's how I think laws like Narega have gotten produced, right? By saying, what would we like? And then creating a pathway to political change, both on the inside, on the outside. I think learning, sometimes just reading about success stories can also give you then ideas about how to come up with legal categories, or how to, push forward politically to make those legal, proposals a reality.
I'm really glad that you're looking at both labor law and criminal law, because I think of all the various legal systems that we've inherited from the British, these have been two really large frameworks, right? And how much critique do you think there has been of this framework in which these laws are? Because there's a question also on obscenity and with respect to feminist perspective. So how does one tie these questions up about the fact that these are laws which have been handed down, and we've barely in law school examined them from that point of view?
Yeah, no, I think that's a very important point. And I think it's actually somewhat sad that we don't have, so almost the next agenda might be to have legal scholars go off and write, decolonize these bodies of knowledge, is to literally go and say, write about legal history for your field, for criminal law, for labor law, for tort law, for whatever it is, for property law. That's such a rich area of legal analysis, because the more we continue to teach these laws as we've received them, I need to step into a law school classroom in India to see, has it changed? Like, how are we teaching, how are we reducing the dissonance that students felt. And that's the dissonance I felt. I think all of us feel that dissonance when we're in a law school classroom and you're being taught a piece of colonial law, which you have, it doesn't speak to your realities at any level. And we carry this dissonance, which does so much harm. But I think one thing in terms of a large-scale research agenda for law schools is really to commission social histories, like of the kind that Alan Norrie has written. So when I would teach criminal law, in the UK, that's one of the first books, and it's a short book, Histories of Criminal Law, is to just link up the socio-political context in which certain criminal law principles were produced, which is the context of the Industrial Revolution, and to say, what has shifted since then? Why do we have regulatory criminal law? What led to the formation of regulatory criminal law? So it's almost as though, this could be the work of, hundreds of PhDs, right? To write social histories of these bodies of law, and then to build that into the law teaching. I think, and these can be short books. Alan Norrie's book actually is not very long. I mean, it's brilliant, but it's not very long. So I think one might simply commission these kind of histories. So unless we do that work, which is really urgent, and we can't really connect up what is happening around us to, what we've studied in law schools.
Any specific comment on the obscenity discourse?
Yeah.
How do you create it?
Absolutely. I think this is, again, I think the feminist scholarship is a very good place to start, because, feminist capture, if you see the debates around, around obscenity in the 1980s, you'll see how different it is today compared to, what happened in the 1980s. And you can see how, given how hypersexualized, I think, contemporary culture in India is, I think you will see immediately the need, why feminists have had to think about, obscenity in a very different way. It's not enough to just be sex positive. Everyone is sex positive to the extent of, having, a lot of what would have been considered obscene in the 80s is just normalized now. So the question now is, is it, why are we continuing to have those battles? And I think, and also what has shifted. So is it more that, the intervention, so the connection between criminal law and technology, I think is quite important, right? And so where in a prior period you'd have said, oh, here are the moral conservatives who think something is obscene and shouldn't be allowed, and you had the feminists who are saying we are sex positive. I think that has completely shifted now, where in fact, there's a new actor, which is the role of technology in making this so readily available. And sometimes the criminal law is not able to keep up, right? Which is why then you have very draconian pieces of law that want to shut down any form of sexual expression. So that older kind of battle with the conservatives remains, but I think it's also an opportunity for feminists to think about what would being sex positive today look like, or have we moved backwards? Because actually what is circulating is, videos of, sexual violence against women, right? Is that a form of backlash against the more sort of liberal exhibitions of, sex positive demonstrations of women's bodies, or, is it something else? So I think let me just say, it's a very fertile area for analysis. And I think it's popping up in many, in various initiatives of the criminal law. You will see that there is a resurgent desire to prohibit pornography, and I think that connects up also with the control over, social media platforms. So trying to pass out the feminist angles and the civil liberty angle, I think all of that makes it a very rich and fascinating area to actually study, to continue to study.
But so I have a question here, and I think the way in which I'm reading it, at least, is that, it seems like there's such a huge disconnect between what we're saying and we're thinking and we want to write about, and what we're actually seeing around us. So how does one, bridge this reality? And, so the question that's coming out is that, how do you not make it just a set of opinions? Nobody is saying it's a set of opinions, but it does seem in that sense as being, very, very, very out of the way. It's not really something that you can actually see around you, because you see the reality, the way in which it acts out around you very differently. So how does one manage that kind of a balance between what you're actually seeing and how you think it should be?
Yeah, I am actually not as pessimistic. I mean, that was quite abstract, but I think there's more. I think the social dial has moved more than we sometimes give it credit. Sometimes I think this question of statement of opinions, I think, is a question also for research, right? I mean, so there, of course, we just have to become sociologists and ethnographers. I think that is the best way to be very empirically rigorous. Go out there and get a sample, right? I think, and this can be even, I know law students, certainly we did a lot of these project reports, and I have to say the project reports that we did while we were in law school still have, sometimes those were the only things that were the only socio-legal studies of the vegetable vendor locally, right? I mean, how much are we scaling up all of this to be robust research agendas? So I think it can start small. Certainly it can start with 25, 50. I think for an ethnographer, even that would be a very high number. But I think doing very robust empirical work will actually test some of our own assumptions about reality out there. And I actually think, and I've always been surprised. I think even things like news footage, certainly when we were talking about wages for housework, people were saying, I think you have to problematize the elitism of feminists here. So there was an assumption that, of course, now all husbands will ask their wives to do, even more unpaid work. Yeah, that's possibly true. You can't discount it. But the reality is, I think when all of those news reports came out, there were these short video snippets. You go to Juhu Beach, and you start talking to people there. Actually, it turns out there's a whole range of arrangements, financial arrangements between husbands and wives, it turns out. And actually, there were husbands who said, I take my entire salary and I give it to my wife at the end of the month. That's one possibility. And there could be the other possibility where actually, they're not giving anything and they're going to insist. And the kinds of men who are going to insist on more unpaid work are already doing that. So I think actually the social reality is much more complex. And I think our conceptual categories are not keeping pace with the shifting, very fast changing social realities. So I think the only way one can dislocate, the statements of opinions is to again bracket our own elitism and not assume that we actually know what's happening, and to actually verify it like a good social scientist would, to literally go out there and talk to people. And of course there are challenges there with, ideally you would do it in 3 cities and, in various socioeconomic classes. That's true. But a beginning is what we need. That final product would be wonderful to do. And maybe it's it could be your postdoctoral research, which you build on and scale up. But I think the starting point, there is room for, very robust starting points.
So 2 follow-up questions, I think, to that. One is absolutely, I mean, when you say you go out there and do research, and there's something that, we often see that you just do a convenient sampling, that is, and people actually say, it's me and, my 2 neighbors and my 2 cousins, and then I will come up with something which I think is research. So in terms of methodology, how does one make sure that there is rigor there? And the second question is, how different should LGBTQI
absolutely
be different from feminist research? So these 2 questions, if you want to tie them together.
Yeah, no, absolutely. So I think that is the thing. So I think if law schools were to do one more thing, and I don't think only law schools, I have heard, PhD students from very elite US universities who have degrees in anthropology and sociology saying that actually nobody ever taught them how to do fieldwork. I don't think it's easy to actually, it's the kind of thing that, I think, yes, we should start with very rigorous modules on how to do fieldwork. And I think there are good teachers, and I think we need to, source these syllabi, put it in a certain place and work through them, have reading groups, do all of that. So I think, that's the first step, to have very sound courses in methodology. But beyond that, I think it's not clear that, we know how to do good ethnography. I think you have to just read a lot of good ethnographic works, even if it's not in your area. I think it's something you learn by just by reading and being very, very rigorous. And even if you can't spend 9 months in the field like an ethnographer would, I think even doing 6 months is good. I think, or doing 6 months and 3 months later, I think that's why social legal research is very powerful, because it doesn't force the disciplinary mandate on you to actually go spend 9 months in the field, because the reality of it is it's also a very gendered call to do ethnography, right? I mean, certainly when you have, if you have small children, or if you have care responsibilities of any sort towards your elderly parents and so on, it's not easy to just go and stay somewhere else for 6 months. I think it's very difficult. But as one of my colleagues said at King's, he said, well, you can either make something very far off, either you can do some very exotic form of fieldwork, which is very far off, or you can make what is familiar unfamiliar. Something very close to you can recast it as being unfamiliar by actually doing. So the ethnographic work could be very close to area. So it has to be feasible, but it has to be very rigorous. And a starting point would be to get trained in social science tools, and then do what you can to create very robust work. I think the question of LGBTQI, I think it's just fundamental. I think that is the most exciting part. And I think also the question of caste. I think it's completely, pulverized many feminist givens. And I think it's the most extraordinary development and the most welcome development, I think, within feminist legal studies and within feminist studies generally. I wish this had happened earlier. I think it's bringing us all back to the point of being students, being a first-year student in a classroom. And I think we should all really take those challenges very, very, very seriously to unpack a lot of our feminist categories. And I think, and I don't want to present it as, so there's a lot of talk about intersectionality. And it seems like a very happy proposal to say, well, this will just intersect with this and that. And, is this that traffic signal metaphor? I don't think always plays out well. I think there's actually more conflict than one is willing to acknowledge. I think we should embrace the conflict as long as it is constructive and it is pushing us ahead with our intellectual agendas. I don't think we should shy away from the fact that sometimes being too beholden to a feminist commitment can actually cause, huge unintended consequences for the LGBTI community. And conversely, there are trans groups who may not be welcoming of sex workers groups. There are sex workers groups who are not welcoming of trans groups. I think there is a lot of, so I think political interests do not align. They don't always align. More often than not, I think they don't align. And I think if that is our starting point, we'll do less violence coming out of our own work. I think, so again, I think I would just bracket, just like you bracket any pre-ordained commitments to particular regulatory outcomes. So, this consistent, your hope is to see a legislation on this looking like this, as long as you bracket that, it's the same thing with, I think, beliefs, political beliefs. I think if we bracket it and keep them open to some of these really fantastic interventions, and maybe we need to take a break from our feminist commitments for some time, because I think we're just so far behind in terms of really understanding how caste-based, so many of our everyday realities are and our bodies of knowledge are. I think unless we stop and listen and think and reevaluate everything we've taken for granted, I don't think we can move ahead, and we're going to repeat a lot of the violence that our intellectual work does.
So Noor, you just put in a couple of dots. Is there something you want to say there? And so I think maybe we should try and do an open house. I think I've taken all the questions which are here. So do people want to simply unmute themselves and ask any question which hasn't been raised or which hasn't come about, or you want to add to that question? You can either raise your hand or you can just unmute yourself, whatever works for you. Yeah, Noor, was there a question that I missed there, or you didn't type it out? I can just
that was a mistake.
I can just see 2 dots. So I was just wondering what was the question there. So this is a question that's coming from Shanti Chandra, who's saying, okay, so I haven't gone to a top grade law school, and this is a question that's come up before also, how difficult it is for people who haven't had exposure to the kind of work that we're talking about. So he would really like some practical, useful sources, books, etc., to get a real insight into legal research patterns, themes, knowledge before actually finalizing the research questions. So what would your advice be to somebody who needs to start fresh? So how does one start reading on like a whole range, body of knowledge that one is not familiar with?
Yeah, I think it's I think that's a really important question, and I'm trying to understand, what would be a good way to do this. I mean, certainly sitting from very far, it seems like there's just such an extraordinary energy in law schools right now in the past 5 or 10 years in India that it feels like, these are some of the questions that we should be able to deal with, quite urgently, and we should be able to deal with. So I think, I'm not, again, the practical part of it, I'm not entirely sure in terms of, access to databases. Like, I don't know exactly what law schools have access to nowadays, but I think let's assume that they're patchy, they're expensive, I'm not sure. But certainly, I think, access to, platforms like SSRN where people post for free, whole range of, if there are particular scholars you're interested in looking at, So I think things like ResearchGate, SSRN didn't exist, 15, 20 years ago, and they are here at your fingertips now, that you can really, whatever area of, and they often have newsletters for particular areas of law. So if you sign up for, if you're interested in, say labor law or whatever, I think you can kind of get access to resources on the, you can get updates, but of course they're not always on Indian law. So, it may or may not be completely relevant, but I think it gives you a feel for how to think about a project, right? So, if somebody is thinking about, I don't know, the property law questions in the US context, right? They're thinking about the single family home, or they're thinking about zoning issues. You can get some of those, how to think about a certain research project is something you can get by just reading these law reviews. I think a lot of US law reviews are also free, right, on their, are open access, so to speak. So you can get very easy access on the journal websites. I think there are also, more and more, opportunities to workshop your own papers. And here I'm thinking about, the Junior Law Faculty Teachers Forum that my colleague Taruna Khaitan organizes, where you can actually present your work and get, friendly feedback. And, of course, all the sort of conferences that, earlier it was last night, and I'm hoping that there would be occasions for those kind of conferences where you can present your work. You can also present work at graduate student conferences. I know the King's India Institute, for example, we just had a virtual conference where graduate students could actually present their work and get feedback. So I think that those might be ways of getting feedback. And I think a lot of if you look at a lot of the major conferences in your field, certainly because of the pandemic, a lot of them were, access was free to them if you come from a developing country. And I'm hoping very much that this will revolutionize the way we all meet and exchange work. So I think it would be good to really look into some of these networks and see what they're doing in the future, and to kind of attend these conferences and follow their work. I don't know. Is that useful?
Yeah. I think that answers his question also about how does one begin to look at research. There is, as you're saying, there's more material available today than that by then was available freely 15 years ago, and so it's a question of sourcing your material and trying to reach out for material. Also, you suggested some areas like if you're looking at your own, where you're located, and just look around you and see what kind of research is possible from wherever you're located, and those are places which are under-researched. So there is tremendous scope for research, and in any part of India, wherever you're located, it's just a question of wanting to open up those for research. So two other questions. You've already listed some areas which can be very useful as research areas. So there are two questions from Rupsha and Devika, which are saying, okay, if you want to say what are the most contemporary and problematic areas of gender studies and human rights law, and the other question is, with the inclusion of non-binary and transgender people, what would be a good place to start research? So just, you've already given many areas in that itself. If you want to add to something there about what you think you're seeing as potential areas of research that people might start wanting to work on.
Yeah, I think, obviously the kind of research agendas we've had, everything's turned topsy-turvy with the pandemic. So I think, certainly, I see that, there's a lot of interest in questions of, identity, and, I think that's very important, I think, and it's very, very good. But I think presenting identity, embedding questions of identity in questions of labor and economic realities of people, I think, are very, very, very critical right now. And so I would simply say try and engage, have a materialist perspective to whatever area that you're looking at, because I think in the next few years, questions around labor, work, livelihoods, income, poverty, are all becoming very critical. I mean, something like, for example, usury laws, right? Not particularly a sexy area to work on. Who wants to work on usury laws? But the reality is, I think there's just such high levels of indebtedness in India currently. If in fact 230 million people are being pushed below the poverty line, what does that mean, right? What that means is that if they don't have livelihoods, they're borrowing at very, very high rates. And certain states are far worse than others, like the state of Tamil Nadu. You get daily interest rates. I mean, it's a complete industry, and there are actually laws that emerge locally to also deal with it. But I think spotting, these very kind of fundamental issues, and I think, and I think it connects profoundly with questions of caste and, trans people. I mean, who's going to bear the brunt of these loss of livelihoods? It's people who already didn't have livelihoods to begin with. Right. So I think I don't see it as an either or. I don't want to suggest, it's not the whole Nancy Fraser thing of, recognition, redistribution, and the conflict. I think in India, most social movements have always presented, both demands for recognition and redistribution. And I think if we keep both in line with each other, I would simply say, try and, focus on the materialist aspects, on livelihood, on labor, because that is likely to both further our research on identity, but also will be most critical sort of post-pandemic.
Especially the whole business of debt. Yeah, you're so right in pointing out that there's such little work that has been done in that area about how much of debt people carry with them.
Yeah. And it actually relates very nicely to the question Isha has asked about, witch hunting cases, for example. So actually, just in 2 days, we're having Silvia Federici speak as part of this project I'm running on the laws of social reproduction. And actually, her work was on witch hunting. She's written seminal books, obviously, on this area. But she's, has also updated that thing of witch hunting. So witch hunting may seem like some obscure practice somewhere. But it's a perfect example of how, if you take a materialist perspective to witch hunting, it's not just a crime out there which needs to be punished, right? But it's actually talking about social reproduction. It's talking about how, as, her thesis is that with shifts in capitalism, women are at the forefront of losing resources to livelihood and to social reproduction. They're often responsible for social reproduction, of their families. And that is when they are trying very hard to then access, resources from the commons. And when they do that, there is a backlash against them to label them as as witches. And it's a way of easing the path of capitalism when socioeconomic resources are redistributed. So I think that's sort of, reading people like that, or having, so if you had a materialist perspective on witch hunting, I think you can pass through all the sensation, the ways in which it's being discussed, and get to the heart of it, which is really the question of how caste and gender intersect in relation to, labor, I think.
So one area that perhaps we haven't really talked about so much is this whole business of judicial interpretation. So how do you think, in terms of PhD area for research, or work that you might have to work for at least 3-4 years, how useful is it to start with legal interpretation, or would you suggest that can only be a part of what you want to do, or can it be entirely what you want to do?
I think it can be entirely what you want to do. You can obviously, delimit it and, have it it depends on your project, I think, but I do think, having done that myself for different areas of the law, I find it actually very powerful, because it gives you a pulse on, of course, how the law is being implemented, of which we can't have enough studies, right? I mean, like, all the most fascinating research that's coming out on the rape law reform is actually ethnographies. It's, people like Neetika Vishwanath, it's people like Preeti Darush who are going out and looking at, what happens when you pass a law, and, this 2013 already feels quite a long time back. Now is the time to find empirical studies of how the law has been implemented, so that when the next round of reform comes, you have something meaningful to say. I think judicial interpretation also is a window into implementation of a certain issue. And you may think that a certain section was introduced for a certain stated aim, and the reality is that it also gives you a window into how the police are interpreting it, for example. So I've been looking at section 370, which is a trafficking provision, and actually seen that prosecutors use it for completely unrelated charge sheets. And it's something that if you didn't study through the case law, you can't actually filter back into a meaningful legal debate on what should a trafficking law look like. And I think the judicial interpretation is even more valuable, because I think there are, of course, activist judges who are reworking entire areas of the law, like Justice Anand Venkatesh. But I think also just looking at the unpaid work analysis that I did, I actually found how sympathetic judges were to understanding the informal economy. How they act and how they were giving us understandings of, how their perceptions of reality mattered. They were looking at how homemakers were actually on par with men. And this may come from, lived experience, but also from the whole range of cases that comes to them. So they have a pulse on social reality in a way that we may not as academics. So I think it could in fact be the focus of an entire PhD project in your particular area. I think it could be very, very productive. That's a great question on bias. Yeah, I know that is so difficult. I think it's really, really hard. And the more and more I think of it, I worry about that for my own work, because I think, I just worry that, as as you become more entrenched in your professional position, how much is your bias seeping through your research and then kind of presenting a distorted view of reality. And I think it's just so difficult to dislodge it, other than you can bracket it, but it seeps through your work all the way. I don't think there's any way of this. Again, I think you can take
please ask the question also differently. How do you distinguish between bias and asking persons to take a position? Because we've been insistent that as researchers you must take a position. So how would you distinguish between being biased and taking a position?
I think taking a position, I think we just have to assume that we're all biased, right? That's the sort of easy response to say we all are biased beings of some sort or the other. The question is, how strong are our biases and how much they determine the research that we do. If it's a bias that can be dislodged easily, nothing to worry about. If it's a bias that's constantly reevaluated because you just happen to read every newspaper that's published every day cover to cover, no worries. You don't have to worry about your bias at all. But I think if you're very dogmatic about your bias and it's influencing, all the research that you're doing, and if you're very, very politically committed to a certain outcome, I think that's where it becomes problematic. So I don't feel like I have any easy answer to it, except to say that the starting point should be to acknowledge that you have bias and that you need to, kind of work through it. I actually find having someone who opposes you to be very productive. They're the best they're the best safeguard against getting too carried away with your own biases. And I think that's, again, I think there is I think people tend to be too polite sometimes in the way that they do have these political debates. And I think I'm not saying become impolite or rude, but I think you have to take risks. Let me just couch it more in terms of taking risks. I think, and not being too committed to getting it right all the time, because you can't in any of these issues. I think, and allowing yourself to, take risks and be proven wrong and then shift your position. I think that's sort of the best way to really, so if you, in your area, if you really have a classmate or a family member or an academic, even better, who completely disagrees with you on your politics of obscenity, engage with them in a productive way. I think that is really, I think, for all the sort of sex work commitments I have, I do think that there are parts of Catherine McKinnon's analysis of the criminal justice system on how it treats sex workers to be completely on point. And I think respecting the political commitments of your adversaries, I think, is being kind to them and expecting that they will similarly be kind towards your commitments, and then not necessarily to bridge or to come up, have a united position. No, I don't think that's possible. But I think just to be sympathetic, and because I think being sympathetic to another person's position requires you to engage very deeply with their work and to take it on board in the spirit in which they wrote it. Like stepping into their shoes really makes you understand fully, rigorously why they're taking a certain position, and then stepping back to see where you disagree with them. I think it's just more than anything else, I think that's how you become really rigorous and free of bias, by embracing and stepping back.
I would want to add on to that by also saying that, how much you build in reflexivity in the way in which you do your research. So to have a position and to be aware of that position and to be open about that position, that you're not sort of like, I would say, you are not trying to hide what you're doing, and I think that open declaration is also an invitation to people to say that, listen, this is your position, and is this position really guiding your outcome rather than the research that you have undertaken? And I feel one way of protecting both yourself as well as your research is to be forthright about that position. Not to be, not to try to, I'm looking for a specific word, not to sort of disguise it.
Yeah, or be defensive.
And also the other dimension is, if you are saying, oh my God, I have to be objective, but you have a position, and because you have to be objective, your understanding of objectivity is that you can't be saying you have a position.
Right.
And I think that's where duplicity starts to come in. That's where dishonesty starts to come in. Whereas it's way more authentic. Whatever we are all creatures of our, our upbringing, our, the setups in which we live and we interact. So it's important to acknowledge it. Somehow the other, people feel that in the name of objectivity that you have to flatten that reality. And I think that's not what it's about, to be doing authentic, honest research. And I think that distinction somehow, it's meant to be that if I feel strongly about something, it's against the whole norm of neutrality. And consequently, the value of my research comes down. Whereas that's exactly, I think, what we need to be telling people, that whether you declare it or not, your position remains. But if you declare it, you're giving other people also an opportunity to question you on that count. Not just, I agree with you with your one strategy that you're putting out, that, look out for people who oppose you, to sort of set up conversations with people who have diametrically opposite views, because that's a way of getting your own threshed out. But the other way also is to be saying openly that this is what my position is, so that when people are evaluating your work, they can kind of, tell you that we don't really think that this is emerging from the reasoning that you have developed. This seems to be more superimposed because of the position you have. I feel it allows for your critics to be able to point out the inadequacies of your work, and you're inviting that criticism. You're not sort of trying to, the point you had made sometime earlier, where you said, be courageous about it, take whatever is. I'm sort of saying, as a part of a larger strategy, that if you declare that this is my position, and I'm willing to be challenged on that count. So the more number of people challenge you or ask you to sort of fine tune your position, you would find that whilst you're keeping your position, the position is not dictating your conclusions. I think that's the basic difference. That distinction is important for researchers to appreciate.
Absolutely. And I think you also have to do it in, I think depending on the topic that you're working on, you also need to have safe spaces where,
Yes.
you can actually because certain areas are extraordinarily polarized, and I think as long as
And
you
you
have,
don't have to be opening yourself up to cannibalism of any kind, where people just
absolutely,
swallow you up alive. That's,
yeah,
I'm not
it's just,
saying that is needed,
no,
but
no,
at
no,
the
not
same
at all.
time, I
Yeah,
mean, sometimes it happens, that very often people are scared of being forthright, because forthrightness then becomes like you're hoisted on your own petard. It's like and that necessarily needs to be guarded against. So let's say you need to protect yourself to that extent. I agree, but I still do think that there is a space for forthrightness, and there's a space for reflexivity, which is a good counterpoint to like being biased on an issue or something. That was my thinking as I was hearing you and the conversation you and Vasanthi were having.
yeah, completely agree. Yeah, absolutely. Mahesh has a problem. I don't know, Vasanthi, should I leave
Mahesh, you
feedback?
want to say it?
Yeah, I thought we'll just do the open house. So Mahesh, if you want to unmute yourself and ask the question.
Hello, am I audible now?
Yes,
Yes, you're
yes.
audible. Please go ahead.
Yeah, a very good evening to you all. So I initially thought to just say the problem, but I was finding difficult how to properly phrase it out. But the problem is, so I have a very keen interest in the study of gender identity and sensitivity, particularly in the context of Indian laws, wherein I see that uh, in the law and in the legal provisions of various laws, we see the use of gendered phrases or words, which results into a very gender biased legal implementation at the societal and very ground level. And I see there are many laws from family to from starting from constitutional to family to criminal law, even to criminal procedural law. And, most of the procedural law is very biased in terms of gender sensitivity. So the problem that I am basically uh, I'm not able to decide what kind of research, like a stepwise, I should take, the work I should do in terms of whether I should just formulate a project, a proposal where I should strive for a comprehensive research work where I would deal with as many laws as possible, which I feel or I see based on the research, obviously, that these laws and the provisions that they use are very gender biased and not at all sensitive to the question of gender? Or should I um, just take one law, let's say a criminal law, IPC and CRPC, and then research on all the provisions that I feel which are very gender biased, and then reaching on the conclusion, yes, that the gender biasness in law is affecting the legal implementation of the ground reality, reaching a conclusion, and then generalizing that a similar situation is there in other areas also. I'm not able to decide whether which way I should go, whether a particular specific law research work or uh, a generalized and comprehensive. I don't know. I'm able to whether I was able to frame that.
No, that made perfect sense. Thank you. I think, I'm sure, there'd be many thoughts on this. Just my sense would be it's a kind of trade-off between depth and breadth, and maybe we want to find some place in between where you say, I'll look at 3 areas of the law or 2 areas of the law which are representative, or it could be that you look at criminal law but look at thematic areas where this seems to resonate more than others. And it's a question of how you want to structure your PhD. You don't have to do everything within your PhD. It could be that you develop a gender theory around how gender identity manifests itself in the law. In fact, one of my colleagues is working on whether there should be a legal gender at all or not. Should gender matter within the law, right? So you can push even further to say, should this be a consideration within the law itself? So create that sort of general theory and then look at, 2-3 areas of the law, and then, expand it for a, postdoctoral kind of research project. If it, so it's a question of how much you can get done within a certain period of time during your PhD, because a PhD is just one snapshot. And you can continue that research later on, but you want it to be representative enough so that you can then feed into conversations in other areas of the law, and build upon that research. But I'm sure there are other ways of also doing this.
Okay, thank you so much.
Does anybody else also have a question that they want to ask?
I would also just want to add on to what Prabha just said to Mahesh. There's always this thing, Mahesh, of matching task to time. That often becomes a way of deciding what your strategy should be. Also, like, you need to assess for yourself, as to, if supposing you want to, like, you want to go the comprehensive route, let's say, then at least half a dozen of those places should be something you're already familiar with. You can still take that route and say, but if you're going to do something where everything is new, just the collating of that entire thing will so exhaust you that you will have no space nor energy left for analysis. That's the reason why generally it is suggested that go for one or two, go for the deeper method, at least for your PhD, because it's still an exam. There are examiners who are going to look out there for what you're doing. There is a pragmatic stance of having your work cleared, and there is a time limit within which it has to be done. It's not like that, this is not desirable or that's not doable, but from a more pragmatic line, it's a suggestion which Prabha has also given you. I would say pick up, go the deeper route rather than the breadth route, because the breadth route has this one very big danger, that you may just skim the surface of lots of things and, really speaking, not be able to come up with something concrete at the end of the day. You've not done enough to be able to make an authoritative kind of, proposition. You can't say that, yes, this is something I have definitively found out, because you've not really looked enough, and you don't have the time to look in depth in a large number of places. So that task to time kind of balance, it's a very pragmatic line. And I still tell everybody, your PhD is not your life work. It's an exam. It has to be done according to certain protocols. It's preparation for your life work, but it's not your life work. It's important to make that distinction and proceed in that manner. And I think because we give a high value to a PhD, so very often when we register for one, we believe that, we're going to take the world by storm. I think you can wait for that for subsequent. Be more pragmatic when you're trying to carve out the space that you want to do. And do that intensely so that no one can, at least in that, whatever is that space that you have carved out for yourself, no one knows anything more than you know. And it's easy to do that comparatively. We are suggesting intrasectionality and all, but when we are intradisciplinarity and all, but when we are saying intradisciplinarity, we are also saying on a single question. So actually speaking, it's on that question that you're going across and looking at things. So Prabha is finding it amusing, but it's like,
No, I completely agree with you. That's why I'm smiling. I think
sometimes it is like, I know it's like it becomes like little bit of a put down for students, because every time when we start an RM course and say, what do you think you're doing when you're doing a PhD? And nearly everybody is saying that it's their life work, and you have to be telling them, no, it's only a degree. It's not your life work. It is like Patricia Broy used to have this thing that this is a pickle that you're preparing, which you will use for the rest of your life, maybe, but it's still just that one pickle.
That's a nice way to think about it.
I really like that, very much, saying that it's a pickle which has been made to last, but so you keep picking from it and trying to add spice to other things that you do, but it's not your life work in the sense of believing that now that you've done your PhD, you don't have anything else to do.
Yeah. No, absolutely. I think that's exactly right. There is life after the PhD, yeah.
So Vasanthi, where do we stand?
I think we should call it a day. I think we've got a range of questions and she's taken all of them very graciously and we've had nice discussions. So I think we should call it a day.
Okay, I hope, Prabha, you also had as good a time as we did in
Yes,
interacting with you. And
absolutely.
because it's sometimes really fun, to sort of excite young people to, this is other things that you can do. And also to recognize our own, like that we can't do everything. So it's important to have allies in different sorts of ways. In fact, our entire purpose behind this series is to build alliances, alliances wherein between young people and between seniors and young people, so that you say, listen, these are things I have thought of, but I don't think I may have time to do all of them, and I'm happy to sort of banto some, I'm willing to share. So it's in that spirit. And I think you've given us a fascinating afternoon in both sharing your own work as well as in seriously engaging with all the young people who had come for this session. And my colleague Vasanthi, as always, has this real talent of being able to thread questions together and ask them in a manner which lends to deep discussion. So thank you so very much, Prabha. I hope this is one of several interactions. And thank you all. And thank you, Vasanthi, for this lovely afternoon. Bye-bye.
Thank you. Thanks a lot. Bye.